Hello everyone, welcome to the NPTEL online certification course titled Medical Law. Our course will have 8-week course, each week as each module. Each module will have 5 lectures. So today we are starting our course week 1 with the first module. Myself, Dr. Chaitanya Mittal, medico legal consultant at Dr. B.C. Roy Multi-Speciality Medical Research Center, IIT Kharagpur. Today we will start our course with a module 1, lecture 1, interface between medical profession and law. The concepts covered will be in the lecture 1, first interface between medicine and law. Second, understanding medical law, health law, medical jurisprudence and the forensic medicine like terminologies. Third, evolution of the relationship between medical profession and law. And the last concept covered will be other concepts of medicine apart from medical profession governed by laws. The important keywords of this lecture will be medical law, health law, medical jurisprudence, forensic medicine and health policies. So coming to the introduction, it is largely believed that law and medicine are separate and unrelated domains, but contrary to the above view, it is found that the discipline of medicine and the law is interlinked in several ways. They have a common path or the common way in between medicine and law. Medical professionals can highly benefit from the knowledge of law. Why should medical professionals study law? Law sets professional standards for doctors and caregivers. Study of law enhances awareness of health policies among medical professionals. Study of law helps medical professionals in addressing the questions of ethics and helps in avoiding medical malpractices. It also ensures that medical practices adopted by medical professionals are ethical, safe and fair. Study of law helps to build doctor and patient relationship and protect the rights of the patients. Medical professionals may also have to participate in trials. How do doctors fall within the ambit of law? We can be explained with the help of this judgment, very famous judgment of Supreme Court case VP Shanta versus Indian Medical Association AIR 1996 SC 550. Services rendered to a patient by medical professional are service within the meaning of Consumer Protection Act 1986, section 210. It is noteworthy that in 2018 the government presented a preliminary consumer protection bill that encompassed services related to the healthcare industry within its definition of service. However, it is noteworthy that the forementioned law did not receive approval from both the chambers of the parliament, that is the Lok Sabha and the Rajya Sabha. The term healthcare was excluded from the newly proposed law in the 2019, that is the Consumer Protection Act 2019, which ultimately became known to be as Consumer Protection Act of 2019. The prevailing legal stance dictates that consumer grievance pertaining to medical services include instances of medical malpractice are permissible for submission before the consumer forums. Nevertheless, if these services are provided without any cost, then it is not possible to lodge a complaint with consumer forum. So, the services rendered which are of free of cost or free of cost of treatment, the patient can't file a complaint in consumer forum. Otherwise, the Healthcare Services comes under as a service as a Consumer Protection Act 2019. Another scenario or another case of the judgment, Dr. Vigil and others versus Ambujakshi T.P. and another in 2022. The Kerala High Court deliberated over the issue of whether the recently implemented Consumer Protection Act 2019 is applicable to health services in the above mentioned case. The doctors put up the argument that the deliberate omission of the term healthcare from the definition of service indicates the Parliament's purpose to explicitly exempt medical services from the scope of the Act. However, the court remained unconvinced by this reasoning and noted that the external assistance such as a draft bill may only be utilized for interpreting a provision if there is a ambiguity within the explicit provision of the law. The court made an observation regarding the clarity and the lack of ambiguity in the term of services. Another case, Lakshman Balkrishnan Joshi case 1969 SCR 1 206. The practitioner must bring to his task a reasonable degree of skill and knowledge and must exercise a reasonable degree of care. Neither the very highest nor a very low degree of care and competency judged in the light of the particular circumstances of the each case is what the law requires. So, coming to the next concept, interaction of medicine and law. The first interaction or the first point will be the legislation and the administration regulations affecting medical practices. Second, court judgments on controversial ethical issues in medicine. Third, medical personnel may become subjects of lawsuits when issues of medical malpractice or alleged medical negligence arise. Last, use of medical matters as evidence in courts for other criminal or civil proceedings. So, let us discuss one by one. So, first, medical matters come into interaction with law in various aspects, especially the four main are legislation and administrative regulations affecting medical practices, like the different laws and acts which are linked with the medical practice. Second, the court judgments on problematic or controversial ethical issues in medicine, like how to practice, how the doctor should behave while treating the patient. So, various other ethical issues while working or while doing medical practices. Third, medical matters or the personnel may become subjects of lawsuits when issues of medical malpractice or even the alleged medical negligence arises, any act done as an commission or the omission which should not be done or which has been done deliberately or unintentionally. The use of medical matters as evidence in courts for other criminals or civil proceedings in all medico legal cases such as homicide, sexual offences, injuries and civil matters like workmen compensation, insurance claims and like that, such more examples in which interaction of medical and law is there. So, the third concept, the important terminologies born out of the interface between medicine and law. Medical law. Medical law is a branch of law which deals with the issues that are legal and ethical in nature and that which relates to the profession of medicine. This branch of law includes rights and the duties of medical professionals, patients and third party payers. Medical law also aims to strike a balance between the needs of society, healthcare professionals and the patient in order to guarantee moral, secure and equitable medical practices. It is important to understand medical law as it is essential for the both patients as well as medical professionals, as it fosters openness, responsibility and equity within the medical domain. Next, health law. Britannica defines health law as the branch of law dealing with the various aspects of health care, including the practices of caregivers and the rights of the patients. Health law are used to formally commit people to objectives like achieving universal health coverage, which motivates people to take action. People use the law to establish various organizations like hospitals or other private clinics and other medical establishments, and relationships like contracts for providing health services in order to facilitate collaboration and accomplish health goals. Third, medical jurisprudence. Medical jurisprudence as defined by Britannica is a science that deals with the relation and the application of medical facts or the practice to the legal problems. For instance, doctors certifying persons for insurance plans, certifying the occurrence of a newborn or the birth of a person or the cause of death, notifying the government of any specified infectious diseases prevailing in the society or community, and determining detention of mentally disturbed persons. Last, forensic medicine. Britannica defines forensic medicine as the branch of science which deals with the application of medical knowledge to the legal question or the application of medical knowledge in the administration of law and justice. For instance, in an instance of death caused by a weapon, the forensic pathologist can examine the wound or the injury and provide detailed contextual information about the type of weapon used, time of causing such wound, reasonable accuracy of the range and the angle of fire, etc. in case of ballistics. So, coming to the next, how the evolution happened between the medical profession and the law, or what is the relationship between the medical profession and the law, how it evolves in this society. So, starting with the Hippocratic Oath, in the 5th century BCE, the Greek physician Hippocrates had formulated the Hippocratic Oath. Hippocratic Oath is an ethical code of conduct consisting of a body of manuscripts called the Hippocratic Collection or Corpus Hippocraticum, consisting of information on medical matters, collection of principles for the teachers of medicine and for their students. According to the WHO, World Health Organization, the Declaration of Geneva, devised by the WHO, adopted by the Second General Assembly in 1948, is a modern version of the Hippocratic Oath. It was written after the Second World War in response to the participation of physicians in crimes against humanity in Nazi Germany. Next, Code of Hammurabi. Around 2000 BC, the great ruler of Babylon, Hammurabi had laid down code of laws to regulate health practices amongst other things. These laws were called the Code of Hammurabi, and it is one of the oldest written laws preserved. The laws regulated the fees payable to doctors for their services and the other aspects of health and medicine. The laws were radical and penalties were imposed for wrong diagnosis as well as wrong treatment. Doctors whose medication were found wrong ran the risk of being killed. Next, famous Arthashastra by the Kautilya's. So, Kautilya's Arthashastra also discussed about doctors and role of doctors in the context of epidemics. He believed that the king should order the physician to use medicine to counter epidemics. Arthashastra also regulated various aspects of health such as duties and the responsibilities of doctors medical professionals and staff, concept of wish and the treatment of wish, king's duty to expend on health, hygiene and upkeep of hospitals. Last, cultivation and plantation of medicinal and therapeutic plants. Additionally, Arthashastra also compiles the plants and the herbs having the medicinal value. Next, what will be the development has come in the 19th century. Colonized India in the 19th century was influenced by the British administration, and the health sector was reformed for the troops and the European civil population. The doctors who were brought by the East India Company were required to be regulated in India. Several instances of indiscipline and malpractice were checked by means of punishment and deportation. Initially, regulations were formulated by the East India Company for the hospitals established by them in British India. Further developments in England, the doctors were registered under the General Medical Council. British doctors who were employed in British India were also registered under General Medical Council. The doctors who were qualified in Indian medical colleges rose in number, and it became the need of the hour to regulate such doctors. Thus, Coroner's Act was made applicable to two cities, Bombay and Calcutta, and the Act defined the role of doctors. Later, Grant Medical College Society in 1880 passed a Bombay Medical Act and established the Medical Council. It involved appointment of a registrar, maintaining list of doctors in the register and punishments for any wrongdoings. So, further development happened in the 20th century. The Legislative Council in India passed the Indian Medical Council Act 1933, which is also now known as National Medical Commission 2019, which established the Medical Council of India or National Medical Commission. The Medical Council of India was constituted as a statutory body for doctors of modern medicine. Post independence, colonial laws were reformed and judiciary to upheld people's right to health care. The institutional infrastructure was developed and enormous acts have been passed to strengthen the healthcare sector. So, the requirements of a medical professional is required to register themselves with the Medical Council of the state of which he or she is a resident, or under Medical Council of India, or also known as National Medical Commission. The medical professional has a right to practice medicine and surgery after following the procedures as prescribed under the Medical Act. Medical councils of the state or the country has a power to warn, refuse to register or remove the name of a doctor who has been sentenced by any court for any non-bailable offence or found to be guilty of any conduct in the professional respect. The provisions regarding offences and professional misconduct which may be brought before the appropriate medical council, either the state or the Medical Council of India, now National Medical Commission, have been stated in the Indian Medical Council Professional Conduct, Etiquettes and Ethics Regulation 2022. So, now last, other aspects of medicine governed by the laws. What are the aspects which have association with both medicine and the law? Is the regulating medical professionals, laws governing hospital facilities, licenses and certificates for the hospitals or the various medical establishments, sale and the storage of drug with the help of Drug or Pharmacy Act, professional training and the research, management of patients, safe disposal of waste by making a Biomedical Waste Management Act, environmental safety, laws regulating medical staff in hospitals. So, these are the various other aspects of medicine governed by the various laws. So, detailing the other aspects of medicine which are governed by the laws, The laws governing hospitals include due process of registration. Laws also ensure that hospital facilities created are safe for the public using them, having all essential infrastructure. Laws also regulate business aspects, licenses, certification required for hospitals, etc. A hospital administrator should be aware about all these laws, regulations, policies, procedure, reports and returns, and keep abreast with the latest amendments to be on the safe side of law and provide quality care to the patients. Other laws pertaining to sale, storage of drugs and safe medication and management of patients. Laws are to be compiled in environmental safety by disposing hospital waste in safe and secure manner, the famous biomedical waste management. The laws also govern employment and management of manpower, public and the staff within the hospital premises. There are laws governing pertaining to the safety of patients. So, the conclusion of our first lecture, from the presentation we can conclude that law impacts medical practice by governing different aspects of medicine and regulating the medical services. It majorly involves restrictions on practice and redressal for wrong patients, or the patient undergoes any wrong treatment or the wrong diagnosis. It majorly has a restriction on that particular medical professional with the help of various laws. Second, a key component of any healthcare system is medical law, which offers a framework for providing treatment and safeguards the rights and the interests of both patients and healthcare providers. It is critical to uphold the rights and the interests of patients as well as the healthcare professionals, guarantee the safe and moral delivery of medical care, and strike a balance between the conflicting interests of different stakeholders. So, these are the references. You can also go through these various references for the further readings. So, first reference we have included WHO, www.who.int for the World Health Organization. Second reference www.britannica.com. Third is a PubMed article. Fourth is the IMA, Indian Medical Association website. Last, World Medical Association website. So, you can go through for the further reading. These are the references. Thank you very much.